Did you know nearly half of Florida residents, which is about 10 million people, live in an HOA? Yep, you heard that right.
One look and I breathe. One
Hi guys, it's Lucy and welcome back to my YouTube channel. Today's video is all about the recent Florida laws that were signed and that went into effective starting July 1st, 2024. So we are going to be discussing about what were the changes that were made to Florida's specifically HOA and condo laws and how this may affect you as a Florida homeowner. Let's jump right into it. And as I go through the different topics about these new laws, it is important to remember that these updates were aimed to improve transparency, accountability, and financial stabilities within residential communities and make everything just a little bit more streamlined for homeowners and people who live in them, as well as board members as well, because they do work hand in hand with a lot of the residents. So it's very important that the property managers on the boards are also certified and trained, and policies will be positive. They don't come with some challenges. So in this video today, I'm going to be breaking down what those positive changes will look like. Let's jump right into it. Annual budget disclosure. So what this means is associations must now provide detailed annual budgets to all members, expected expenses and reserves. This changes ensures that all community members are informed about how and where their fees are being utilized. Reserve studies. New laws mandate regular reserve studies to ensure that associations have adequate funds for long-term capital improvements and repairs. Associations must disclose the results of these studies, any plans to address funding shortfalls, including special assessments. Audit requirements. Associations with a budget exceeding a certain threshold are now required to undergo annual independent audits. This aims to enhance financial accountability and prevent mismanagement. Transition to board governance. So along with these financial changes, the legislation also introduced new rules to improve board governance and member engagement. Essentially, these financial reforms pave the way for improved governance, which is the next focus of the legislative updates. As we move from financial matters, the focus shifts to improving board governance and increasing member engagement. From my previous video, I did not talk about the fines, suspensions, and liens, as this also recently went into effect. So I would like to talk to you about that next. So associations must have a hearing before a committee to review a fine or suspicion issued by the board in the bill. It requires a 14-day notice of the parcel owner's right to a hearing to be in writing. Requires the hearing to be held within 90 days of the notice of the hearing. It also allows the committee to hold the hearing by telephone or other electronic means. It also requires written findings related to the violations to be provided within 7 days of the hearing. The date that the fine must be paid, or if the suspicions fulfilled, requires the day by which the fine must be paid for at least 30 days after delivery of the written notice of the committee's decision, or prohibits attorney fees and costs based on actions taken by the board before the date is set for the fine to be paid. Allows that if a violation in the proposed fine or suspension is not cured or the fine is not paid, reasonable attorney fees and costs may be awarded to the association, but may not begin to accrue until after the payment date of the fine or the appeal time has expired. So these are all new things dealing with fines, suspensions, and liens against a homeowner. Board training. Newly elected board members are now required to complete a certified training program on governance and legal responsibilities within 90 days of an election. This ensures that board members are well equipped to manage their duties effectively. Term limits for board members. To encourage fresh perspectives, the new law imposes term limits on board members, preventing individuals infinitely. This helps to foster a diverse and a dynamic board composition. There will be open meetings. The law expands requirements for open meetings, speculating that all board and committee meetings must be open to residents, except for certain confidential discussions. This promotes greater transparency and allows members to stay informed about community decisions. Transition to resident protection. So these government enhancements are complemented by new measurements aimed at protecting the rights and the interests of residents. Overall, I think these government improvements are designed to ensure that the board operates effectively and that community members have a voice in their management. Building on these governance changes, the legislation also introduced new measures to protect residents' rights and interests. There was also several new provisions focusing on protecting residents' rights and ensuring their voices are heard within the community. I think that's great, so let's jump right into it. So, voting rights and processes. Basically, the law streamlines the voting process for board elections and community decisions, making it easier for residents to participate. Election voting systems are now encouraged, increasing both accessibility and likeliness for higher voting percentages. This is great because I know in my community, we're in a short-term community area, and so we have a lot of out-of-state and over abroad that don't live here full time. And so if we are able to now streamline the voting process to get stuff done for full-time residents or even just their home in general, if they can participate in the voting system instead of being in person, I think a lot of changes will happen because of this as well. So for me, I am very happy to see that they strengthen residents' protections in this provision. Dispute resolution mechanism. So this legislation introduced more robust mechanism for resolving disputes between residents and associations, including mandatory mediations for certain conflicts. This would also aim to provide fair and efficient solutions to common issues. Short-term rental regulations. New restrictions on short-term rentals within HOA and condos communities have been enacted. These regulations seek to balance the needs of long-term residents with the interests of owners who wish to rent their properties on a short-term basis. These resident protections definitely ensure that community members have a fair and straightforward process for participation and disrupt resolutions. Understanding and implementing these changes can be complex, but I'm here to help you navigate those new HOAs and new regulations successfully. And if I don't know it, I'm more than happy to refer you to a real estate attorney who can explain the process more to you and interpret the law, because as my job as a real estate agent, I don't interpret the law. I just try to keep update with these new laws and regulations that will affect homeowners and just to educate my clients. But to interpret the law, you definitely need to go to a real estate attorney. Also, as HOAs and landlords work to comply with these new regulations, understanding the broader restrictions on landlord behavior is also very essential, as a lot of homes here in Central Florida are landlord owned, and there are quite a bit of rentals in the area. There are quite a bit of new changes that will definitely impact landlords. So what a landlord cannot do in Florida. So there are some specific laws designed to protect tenant rights. So let's kind of talk about this section of the new provisions that went into effect as well, because it is very crucial to understand. It's going to be helpful to you as landlord with your tenants to maintain that fair and lawful landlord-tenant relationships within HOAs and condos. So here are a few key prohibited things that landlords must observe. So, unlawful evictions. Landlords cannot evict tenants without the following legal process. This includes providing proper notice and obtaining a court order. Self-help evictions, such as changing the locks or shutting off utilities, are illegal. Discrimination. Under the Fair Housing Act, which is not new, landlords cannot discriminate against tenants based on race, color, religion, sex, national origin, disability, or familiarity status. This includes during the application process and throughout their tenancy. Privacy violations. Landlords cannot enter a residential property without giving reasonable notice, typically 12 hours in advance, and must do so within reasonable hours unless there's an emergency. Tenants have the right to the quiet enjoyment of their homes without unwarranted intrusion. Withholding essential services. So it is illegal for landlords to withhold essential services such as water, electricity, or heat as a method to force tenants to comply with their demands or vacate the property. Maintaining habitable condition is a legal requirement. And then, of course, landlords cannot retaliate against tenants for exercising their legal rights, such as filing a complaint about unsafe living conditions or joining a tenants union. Any form of intimidation, or penalty for such action is prohibited. Well, guys, that was a quick legislative update for the 2024 Florida legislature in regards to Florida bills that impact homeowners here in Central Florida. Thank you for watching, and I'll see you in the next video. Bye.